Hi everyone. No doubt you have heard a lot from us about the Attorney General's implementation of a law from last year that was intended to address drip or bait and switch pricing at specific California businesses. That law, SB 478, starts on July 1st. SB 478 is meant to prevent drip pricing, where consumers see an advertised price but are subject to additional undisclosed charges at purchase. Under the law, this practice is a violation of the Consumer Legal Remedies Act. However, questions have been raised about whether SB 478 applies to restaurant menus, specifically whether the legislation was intended to ban service charges and other surcharges that have long been common at restaurants, even when the charges are prominently disclosed in advance. Prior to the passage of SB 478, courts consistently concluded that menus were not advertisements, and that food items on a menu were not goods and services, as that term is defined in the CRA. The law's co-author, Nancy Skinner, publicly stated the law would allow restaurants to continue charging service fees so long as the fee was disclosed on the menu clearly. And even when the law was signed in October 2023, the Attorney General's office stated SB 478 would not bar restaurants from charging service fees. Those fees, however, must be disclosed so they are no longer hidden in restaurants' advertised prices. But since we're doing this video, you've probably figured out that's not what's been happening. After the law passed, the Attorney General's office has incorrectly interpreted the new law, saying restaurant surcharges, auto-gratuities, and service charges are a violation even if they are clearly stated on a restaurant's menu. The Attorney General's office, including restaurants in the implementing Q&A document for SB 478, feels like the ultimate bait and switch and is an erroneous interpretation of the law. Taking action, we sent CRA members a copy of the letter our legal team immediately sent to the Attorney General, rejecting their expansive interpretation of the law and demanding they revise their implementing guidelines. Our legal team is considering all options, including going to court. Along with that, we are on the ground every day lobbying in the state capitol to get a legislative clarification done prior to the July 1st implementation. Meanwhile, you have been amazing at responding to our multiple email action alerts, providing you with a quick and easy way to communicate directly with your lawmakers about this urgent issue. The CRA restaurant community has generated over 1,500 individual letters to lawmakers on this topic, and we thank you for such an amazing response. We are building momentum in the legislature to get the much-needed clarification into law. The legislative leaders behind the original SB 478 are also leading the charge with us. Senator Dodd told the New York Times, quote, "My motivation in authoring the bill was to stop deceptive advertising in sectors that have drip pricing and hidden fees that appear at time of payment. So menus with clearly disclosed fees weren't my intended target." End quote. So whether you currently use service charges, auto-gratuities, or surcharges or not, we are fighting to preserve your right to decide to do so in the future. We know many restaurants increasingly use these properly disclosed charges to help provide non-mandatory benefit packages to their team members. While time is short, we will continue to do the daily lobbying in the state capitol to push this critical issue forward. That's the news you need to know. Thanks for watching. See you here next time.